Right, I think we're ready to start. Everyone's joined us, hopefully. So welcome to 3PB's webinar on injunctions and employment and employee competition. You've got Colin and I today speaking. Colin's going to be speaking in just a moment, but before we start, I just wanted to have a quick word, if I may, about one or two things and perhaps plug the group, if you'll forgive me, just for a moment. If this is your first webinar that you're participating in, I should let you know that there are 10 of these for you to watch at your leisure on YouTube. So if you go onto the YouTube site and search 3PB employment, you'll find those videos quite easily. If you can't find them for whatever reason, then get in touch with Russell Porter or somebody in our team, on the clerks in our team, and they'll be able to point you in the right direction. There's some useful stuff on there, very contemporaneous. There's a webinar on redundancies, changes to the Employment Tribunal rules recently, the updates on disability discrimination, and more importantly, all the COVID changes that have been happening recently. So you might find those useful. There's also case law reviews that we do. These are pretty much a summary of the case law email that we send out, the newsletter that we send out each month. So if you're not getting that, then you should also, it's worth contacting one of the clerks and asking to be put on the list, because you'll get that at the start of each month, and it's a very useful summary of all the cases that are relevant to employment law that have come in the last month. So that's just a plug for the group. Now, the only other thing I'd ask you to do when you are asking questions, if you want to ask questions, could you please use the question and answer box on your Zoom screen rather than the chat? The question and answer box will filter through in the right way. So if you could use those. Other than that, I don't think there's anything else I need to say. And without further ado, I'm going to hand you over to Colin, who is going to start the talk on a case law update. So over to you, Colin.
Is that you can see the first slide for the Restrictive Covenant seminar that we're going to be delivering. Naturally, because this is a short thing, this is just going to be an overview of restrictive covenants, mainly in the employment area, but I'm also going to cover restrictive covenants in the commercial arena too. It's going to be, I hope, a refresher for you. And at the end, I've got some case law that I've found in the leading textbooks and also online resources. We'll have a quick canter through some of those case summaries to see how the courts have been applying restrictive covenants. So let's begin. Let's kick off with, why do you have restrictive covenants? What's the need for them? What's the purpose of them? Well, of course, we all know that employees have access to confidential information, customer lists, price lists, things that are important for the businesses that they're employed by to keep confidential. And what employees might do is they might decide that they're going to use some of that information or some of the contacts that they have with customers or clients in their new job. Maybe that's going to give them a sort of a springboard in their new role, and they can hit the ground running with information and clients that they bring with them. Or even perhaps they're going to set up in competition with the business that they're leaving. And of course, if you're the business that the employee is leaving, you want to be able to restrain that sort of behavior. So implied terms in contracts of employment won't work. The main reason for that is that implied terms are only valid during the currency of the employment contract. So once the contract of employment ends, if there was an implied term that's a restriction of some sort of behavior, then that wouldn't roll over to stop the ex-employee behaving in a certain way in their new employment. So instead of implied terms which don't work, we use express terms, and we have restrictive covenants that are drafted specifically for the purpose of restraining behavior. And those express terms have a number of advantages because, well, first of all, we can tailor what those terms contain. We can tailor those terms to the particular needs of the business that's concerned. And if those restrictive covenants are reasonable in their nature and their extent, they can restrict the post-termination conduct of the person who's left. There's another advantage in having express restrictive covenants, and that is that it might actually deter the employee from leaving in the first place. Because if the employee thinks that I'm going to leave and I'm going to have a ready-made customer base and information that I need to start off in my new role. But actually looking at my restrictive covenant, it seems clear that I can't do that. Then it may stop them from leaving, as I say, in the first place. The further advantage is that it might actually also stop the new company from recruiting that person. Because as they should do, they should look at the restrictive covenants of the person joining them and determine whether or not the new employee will be in breach of those restrictive covenants. And in so 99% of the cases I deal with in relation to restrictive covenants and their enforcement, we always have the new employer as a second defendant, because, well, the main reason is because they've got deeper pockets than the poor soul who's going to be named as first defendant. And then the company is therefore more likely to be able to satisfy the damages that arise from any breach of the restrictive covenant. So drafting express terms have those advantages. And of course, the reason that the new company might be liable and for a breach of restrictive covenant is for inducing a breach of contract. That's the cause of action that we take them under. So that's the need and the purpose for restrictive covenants. They are unlawful because they're a restraint of trade. However, as you'll see on the slide, they're not unlawful if the two bottom bullet points in the slide are looked at. It is lawful to restrain if there is a legitimate proprietary interest that is being restrained, and it is also lawful if that protection is no more than the minimum that is reasonably required with regard to what the legitimate interest is. Courts will look at the parties' interests of the employer and the employee, and also the public interest when determining whether the restrictive covenant is the minimum that's reasonably required. So some of the key principles for restrictive covenants are on this slide. Reasonableness, and that is determined at the time of entering into the covenant. And one of the case studies that I'll take you to at the end discusses that. There needs to be a legitimate interest. The next slide that I take you to will deal with that in a bit more detail. There is a difference between employment and commercial contracts as to the enforceability of restrictive covenants, and I'll touch upon that in a moment. If the sole purpose of the restrictive covenant is simply to prevent competition, well, the courts are not going to help with that. That's an insufficient reason for a restrictive covenant, if that is the sole reason. And lastly, as I mentioned a moment ago, restrictions must be no wider than necessary. So coming back to reasonableness, and reasonableness at the time of entering into the covenant, well, that's a question of reasonableness that the court looks at the time the covenant is entered into, not in light of subsequent events. So, for example, a trainee solicitor who joins a law firm might well have restrictive covenants, or a managing partner who enters that law firm might have restrictive covenants. You would expect them to have different restrictive covenants. And in a situation where the trainee joins the law firm, but has onerous restrictive covenants that are more akin to perhaps those you might see from the managing partner, but that trainee stays in the law firm and progresses up through the years and is promoted up to the position of a managing partner, what might happen is that those restrictive covenants that were agreed at the beginning might actually now be appropriate for someone who's a managing partner. But be very careful that the courts will not look at the restrictive covenants at the time that the trainee is now the managing partner. The court will look at the time that the trainee joined, and those restrictive covenants may well not have been appropriate at the time the trainee joined the law firm, and therefore they may not be upheld. So that's reasonableness, the entering into at the time of the covenant. Legitimate interest, as I say, I'll talk about in a moment. Employment contracts versus commercial contracts and restrictive covenants in those two arenas. Well, if you think about this, that an employment contract, the parties to that are the employer and the employee, there's likely to be a difference in bargaining power in that relationship. And so courts are probably going to be less likely to uphold a restrictive covenant if it's in an employment relationship. compared to if that restrictive covenant, the same restrictive covenant, had been agreed to in a commercial contract, maybe in a share sale agreement, or with the sale of goodwill in a company. That restrictive covenant may well be more likely to be upheld because there's more likely to be equality of bargaining power there. And if you think about it, really, if you're selling goodwill of a company, and then you set up in direct competition to that company, the thing that you've just sold, i.e. the goodwill, is now worth much less than it was, because you're setting up, you're competing, and you're sort of undermining that goodwill. And the courts are going to be quite keen to uphold a restraint in those sort of scenarios. And there's a great quote from a case that's 125 years old. It's still good law, from 1896 in the Court of Appeal. Lord Macnaghten was sitting in judgment on that case. And it is not right, said Lord Macnaghten, it is not right to profess to purport to sell that which you do not mean the purchaser to have. It's not an honest thing to pocket the price and then to recapture the subject of sale, to decoy it away or call it back before the purchaser has had time to attach it to himself and make it his very own. So there you go. For 125 years, the courts have recognized that you can't go selling, for example, goodwill, and then immediately undermining it and reducing its value to perhaps nil. And the courts will restrain that sort of behavior. So that's reasonableness. I said I would come back to legitimate interest, so I'll move on to the next slide. So restrictive covenants are there to protect legitimate interest, but what is a legitimate interest? Well, as the slide says, it's things like trade connections, so customer lists, client lists, suppliers, includes goodwill. A legitimate interest also will protect trade secrets or confidential information, and a legitimate interest includes stability of the workforce. What I suggest at the bottom of this slide is that employers define what that legitimate interest is at the outset, so there's no argument about it, and define that legitimate interest carefully. So it's good to express what that legitimate interest is. That legitimate interest may change over time, and the definition would therefore need to be amended as time goes on, and that is acceptable, and in fact the preferred way of dealing with that. What about the trade connections and how that fits into being a legitimate interest? Well, relationships with customers, clients, etc. What you find is that employers create those relationships, they build those relationships, they gain trust, and then they use them for transacting business. So what you might find is that when an employee leaves, is that a customer wishes to follow that employee. And in fact, sometimes the customer takes the first step and contacts the leaving employee first. So those can be dealt with by non-solicitation restrictive covenants or non-dealing restrictive covenants. But those clauses have to be no wider than reasonably necessary to protect that trade connection. So for example, there's a case in 1995 where a broker was given a £10,000 budget to spend on entertaining. This is, of course, pre-Bribery Act. I'm not so sure this would stand up now. And that £10,000 was spent on building relationships up. And the court protected those relationships, granted an injunction to enforce 6 months worth of garden leave, saying this, that there was a lavish and expensive budget, and that created goodwill. And that goodwill was entitled to the protection of the courts. So that's a sort of customer relationships that can be protected. Trade secrets and confidential information, well, all employment contracts that I see express that sort of information is not to be used or disclosed. Don't normally see a problem with that being defined as a legitimate interest. Stability of the workforce. Well, there is, of course, value in a stable, well-trained workforce. That's an interest that can be the subject of protection, particularly if it's a smaller employer, because 4 or 5 people leaving can be half the workforce. Very difficult to recover from that. So very useful to be able to protect a stable workforce. Or equally, an employer who invests a lot of money in training and has a very well-trained workforce will want to protect that workforce from poaching. So a non-poaching restrictive covenant can be used there. And that would help to avoid team moves, which is something I think Stephen's going to deal with when he gives us his talk after mine. So the next slide tells us the sort of restrictive covenants we commonly see. There's a hierarchy here that the restrictive covenants at the top of this slide tend to be easier to enforce, and as you descend, they become more difficult to enforce. Apart from non-poaching, which for some reason I put out of order, that perhaps should be second in the list. But in general, as you go down the list, they're harder to enforce. So non-solicitation, that generally means your employee taking positive action to contact a client or a customer. But that, as I said before, it's not always the case. Sometimes the customer contacts the employee. It's a question of fact and degree, and there can be fine lines in this sort of thing. So, for example, there's a case where an ex-employee set up a new business, had their own headed note paper with their contact details on the top, and wrote to all of their previous contacts saying, I am leaving on this particular date. Now, that's fine to do that, but what this person then did, which was not fine, was then to say in the next sentence, and you can contact me on the above details. Now, you might think, well, that's a rather superfluous sentence, because the whole point of headed notepaper is it gives you the contact details of where you can get hold of me. But by adding in that extra line, that was a solicitation, the invitation to contact me as above. And the court restrained the ex-employee from dealing with customers. Customers should be defined as those with whom the ex-employee had contact with in a period just before they left work. So maybe 6 months or 12 months, as is appropriate beforehand, rather than all customers of the company that we had. And one of the case law summaries that I'll take you through deals with that aspect of things too. What about in the social media age and LinkedIn profiles? Some people may come to employment with a good following. And will that be the subject of a non-solicitation restrictive covenant if they come with those people? Well, actually, the answer is there's no implication that they will be excluded from non-solicitation. So advice to give to an employee who comes to a new job, if you're advising that employee, is to make sure there's a carve out in relation to the relationships they've already got, perhaps to set out who those people that they bring with them are. So not implied, you need to have an express term to that effect. Non-dealing, well, the benefit of a non-dealing clause is that there doesn't need to be solicitation. You don't need to say who approached who. All you need to say is that you're dealing with, you shouldn't be dealing with somebody. Less likely, as I say, to be upheld than non-solicitation, but depends on all the circumstances of the case. A non-compete clause tends to be seen as the nuclear option. It's the kind of heavy weaponry in an employer's armory. Again, less likely to be upheld than the other two clauses that I've mentioned a moment ago, but useful in something like a manufacturing process. Maybe, you know, if you the Coke recipe, something like that, where non-dealing, non-solicitation, non-poaching is unlikely to protect that sort of information. Tend to be more used with more senior employees or you know, senior engineers, something of that type. So that's a non-compete clause. Trade secrets I put there in square brackets because although they do tend to be the subject of restrictive covenants, there's also a common law protection against using confidential information as well. Let's go to the next slide. Restrictions need to be no more than is necessary. So geographical restrictions apply. If you're drawing a radius around somewhere, you need to know how big that area is, what's the nature of the area inside that radius. Is it urban, for example? A half-a mile exclusion around in Bury St Edmunds is going to be very different to a half-mile exclusion in Manchester, for example. Less common now, geographical restrictions. You tend to see them with things like hairdressers, businesses where there tends to be a shop and a catchment area around it. But as more companies move to an online presence, geography becomes less important, but they're still around. Duration of restrictive covenants, that's important to get the minimum necessary. Confidential information can well sometimes be permanently a permanent restrictive covenant in using it, depending on if that information becomes obsolete or not. So when thinking about duration of restrictive covenants, think about, well, how long is it before the employee's replacement is up to speed, before they've settled in and cemented those relationships? And that might be a good indicator of how long a restrictive covenant needs to last for. What's the shelf life of our price lists? How long is it before our information goes out of date and becomes stale? That sort of thing. Or in an insurance broker's business, if there's a need to contact people who take out insurance on an annual basis, then a year might be a good marker, if that's a sort of frequency of contact. Generally, high turnover, short notice period businesses, you'd have a shorter duration, whereas highly specialized industries where there's a skills shortage and difficult to recruit, you might expect there to be longer duration of restrictions. If there's an industry standard, that can be helpful, although it doesn't tend to be determinative about these things. Severability of clauses. I'm sure everyone's familiar with the Tillman case that was in the Supreme Court last year. There's been a lot of discussion about it. Severability survives. So there's a blue pencil test where the court may take a blue pencil and scrub through certain words. Of course, what you're not allowed to do with that is add any words to a clause. It's only taking words out, and you must retain a sensible meaning once those words are removed. Once those words are excised, there still needs to be consideration. Not normally a problem in employment contracts because of salary that's being paid, and that's normally taken to be consideration. But also, there needs to be no major change to that contract, and that's not quite clear what that means. I have seen some commentators talking about what no major change means, and there's a lot of debate about it, so there may well be fertile area for litigation in the future. What about discharge of restrictive covenants? When do they come to an end? Well, always good to have a look out for claims where there's wrongful dismissal. So if there has been dismissal without notice, and that's unlawful, that there should have been notice, that brings a contract to an end. Because it brings a contract to an end, it brings the restrictive covenants to an end as well. So that's an important point to look out for. Or constructive unfair dismissal. Of course, for that, we need a fundamental breach of contract. And if there's a fundamental breach of contract, that brings the contract to an end. Also brings the restrictive covenants to an end as well. Interestingly, for constructive unfair dismissal, although on the unfair dismissal part of the claim, the employee needs to resign in response to that fundamental breach in order to be unfairly dismissed. For constructive dismissal to end the contract, not necessary for the employee to resign in response to the breach, because they may only in fact become aware of the breach after the termination of the employment. So again, another one to look out for. And then finally on this, pay in lieu of notice. If there is a pay in lieu of notice clause, which I guess most contracts ought to have, then that doesn't bring the contract to an end if notice is given. And the restrictive covenants will continue. I'm just going to deal with two of the cases I've set out. I've set out 9, but they are varying in their levels of interest. The two I'm going to do, I'm going to skip past the first one and the second one, and I'm just going to go to this one, which basically shows everything that can go wrong with the restrictive covenant clause. This is a case where there's a very junior employee who had a 6-month post-termination clause from dealing with customers, etc., in a massive area. You see there, it says Kent, West, all the way to Dorset along the south coast. Huge. Not upheld, said the court. And the reason is, if I go to the next slide, because this person was only a trainee when the clause was entered into, and therefore the terms were manifestly inappropriate for someone of that level. Second thing that was wrong with it was that that person only dealt with 1% or customers that contributed 1% to the turnover. So therefore you can't exclude all customers. That's just manifestly inappropriate. There wasn't a definitions area. so that it was difficult to know what similar nature meant. And then lastly, there was a strange clause that said that the employee would be paid during the currency of those that 6-month post-termination restriction, and that was contrary to, even if he had a new job and was getting more salary, and that was contrary to public policy. The last case I'm going to go to is in fact the last one on the slide, so I'm going to skip past these other ones. You can have a look at those in your own time. They're quite easy to read. And I'm going to get to this last one, which is this one of a team move, which might lead nicely into Stephen's talk, as he's going to be giving us very shortly. This is a case where there wasn't even a contract, and so therefore no post-termination restrictions. This was a senior employee, an operations manager, who effectively was going to pass off his new venture as his employers. He was going to set up a new domain name, use their premises, etc., nick some of the staff. And it was held that was a duty of a breach of the implied duty of fidelity by failing to warn the employer that that was going to happen. And he was restricted from doing that, despite there being no restrictive covenant. So interesting from that point of view. So I hope you found that useful. I'd say it was rather a whistle-stop tour through an introduction to restrictive covenants. I'm going to hand over to Stephen now, and to do that I need to stop sharing my screen, and I may see you at the end if there's some questions that arise. So Stephen.
Right, hopefully you can see me. I think my camera's moved for whatever reason. Anyway, hopefully you can see me. Thanks very much, Colin, that's great. Now I'm going to look very much at the practical side of things. We're going to move away from the law now and look at things from a very much a client perspective if we can. So I'm going to share the screen, but first of all I've got an apology to make because for whatever reason when I've transferred these from my laptop to the iPad, the slides are actually not coming up as well as they should, and the text is being blocked and obscured by the pretty pictures on the slides. Entirely my fault. Because apart from anything else, it's telling me that I've obviously put too much text on a slide. But there we are. That's a message I'm going to obviously have to take away from today. But what I would say is that hopefully, I mean, I'm going to be going through everything that's on the slides anyway, so it shouldn't be a problem. Some of it you will be able to read and see anyway. And if you want a set of my slides, you're very welcome to have a set. I can forward them to you after the webinar. Just get in touch and I'll forward them on to you. So as you can see, the purpose of the talk that I'm going to give is the practical considerations that people need to think about when it comes to restrictive covenants. We're very quick to turn to law books and look up all sorts of things about how to draft restrictive covenants, what the case law is on these things, but actually taking a step back from that and giving some useful, practical, hands-on advice to your clients is really what's going to set you apart from those people in other firms who might attract the business from you. So just turning to the first question, I mean, whenever a client gets on the phone to you, no doubt that one of the first questions that you will ask them is, well, is there a contract? In fact, I would probably hazard a guess that the vast majority of people watching this today, that's one of the first questions they ask their client. What they don't ask their client is why? Why is your employee wanting to compete with you? What's the reason for that? What's behind all of this? And again, as I say, lots of people, when people come to us, when clients come to us, they expect from their legal advisor more than just a legal encyclopedia. Anyone can go to the books, find the case law, and find the answers if they really work on, or at least work on what they think the answer might be. Sometimes there is no answer, you have to work it out for yourself. But what the client wants and what sets you apart from your competitor solicitor down the road is if you are a strategic thinker and if you can offer that added value, something different. And so the first question really you ought to be asking is not is there a contract, but why are they doing this? What makes you think that they're doing it? And so looking at the next slide that asks this question, these are the sorts of things that you should be discussing with your client from the outset. Is the employer motivated? Do they have an appropriate work-life balance? What about leisure time, family commitments, outside business interests? They might well have an outside business interest. There might be an old family business that they want to put some time into, that they want to develop for themselves for whatever reason. There's nothing wrong with that if that's not going to compete with your client's business. The career structure, is it an inviting career structure? Is it encouraging people to stay within the organisation? Now, you might say, well, this is all great, but the client's going to be pretty hacked off if they come to me wanting to stop what's going on, and I start discussing, the benefit of hindsight, a bit like my mother, whenever there's a problem, she's very good with hindsight. You might feel that that's what you're doing with your client. But the answer to that is if they say, well, thanks very much, Stephen, but this is all great with the benefit of hindsight. Now, it's not hindsight, because Sam, who's now cleared off and gone and worked for a competitor, sat next to Tim and went out for lunch with Tim every day. And they were good buddies. And then, and Tim, of course, is going out with Sue. And the question is, Sam's gone. What about Tim? What about Sue? What about the rest of the team? What about the rest of your workforce? Is anyone else likely to just up sticks and go? And if you don't answer these questions, if you don't look at these questions, never mind the damage that's been done already, you could be sitting on a very serious commercial problem. So these are very important questions and discussions to be having with your client right at the outset. Of course, you've got to get down to the nuts and bolts of the contract with the individual who's concerned. And all of that. But at the end of the day, what you've also got to look at is protecting the business, protecting your client's interests as much as you can, and containing the problem. So it's not just about asking, focusing on the individual concern. It's about focusing on the business as a whole. The next question, and the next thing you need to discuss with your client, if you're looking at that and thinking from a strategic point of view, is the long-term incentives. What are the long-term incentives for the existing employee, perhaps, who hasn't thought about that when they are talking about leaving? They come to you with their resignation, come to the client with a resignation. What are the long-term incentives for those people who work with the employee who's talking about clearing off and working for a competitor? So shares, cash, holiday, sabbatical, these are all things that you can do and you can advise your clients on to encourage people to stay in the workforce and to actually preemptive steps to stop any kind of threat of competition. If your clients give these great incentives, then they're going to minimize any risk, serious commercial risk to their business. So these are very simple things. And of course, the great thing about this, and I'll come on to monitoring in a moment and policies, the great thing about this is it gives you an opportunity to go to your clients right now when you finish this webinar and start your marketing. You can this is an opportunity for you to get back in touch with those clients who you haven't spoken to, maybe for a year, maybe for a year and a half. And you say, look, I just had a thought, or you might even say, I've just done some training with on injunctions, and it's reminded me, you haven't had your policies checked for 2 years. And with all that's been going on with COVID and people working from home, it's a really important time to do this, because you could find that you've got members of your workforce who are effectively leaking very, very valuable commercial information to competitors. So this is a great opportunity to market. And again, you can use the long-term incentives as an opportunity to go back to your clients and say, have you thought about some of your senior employees who you do not want to lose, setting up some forms of long-term incentives to keep them in the business? Now, of course, you've got to be careful, because some sectors and industries have their own regulations. Finance and pharmaceutical sectors I've identified on the slide, but those are the things you've got to think about. Promotion and management. Do you want to promote somebody into a position just to keep them on side? Of course, the promotion has the benefit of creating a fiduciary duty, possibly. If you put them into a management position, then you might even enhance their obligations and their contractual duties to you, because, of course, if they've got fiduciary duties as a manager, then any serious breaches of those are going to be easier to eradicate. So then, turning to the next part of the talk, which is spotting the signs, putting the preemptive work, if you like, to one side now, and what you can go back to your clients and suggest. The next question is spotting the signs. This is the next discussion you should be having with your clients, just on a general basis. Are you keeping alive to the possibility of your employees competing with you and going off to a competitor? So what are the practical steps that you can use when you're dealing with spotting the signs? Of course, the approach that you suggest to your clients will very much depend on the nature of their business, how their business operates, the likely competing activities, the time and money and resources of the client that they can commit to the process. You've also got to advise the clients of the dangers. And one obvious danger is if you create or if your client creates a culture of mistrust or distrust, or whatever term you want to use, then it's not going to necessarily have the positive effect that you want it to have. And it could, in fact, go further than that. You could find yourself in a situation where your client, the employer, is breaching the implied term of mutual trust and confidence between the employer and the employee. A good example of that is setting up CCTV to monitor what's going on in the workplace. That's an extreme example, I appreciate. But setting up CCTV without telling your workforce. Even things like monitoring emails and computer use, monitoring the photocopy of the printer, which again I'll come on to. If you haven't set that out in clear terms, that that's the sort of thing you are entitled to do, and that's what you will do for good commercial reasons, to make sure that everybody, you can dress it up how you like. I mean, it's whenever you make a phone call to an insurance company or a I don't know, telephone company, whoever it might be, they always say this call's being recorded for monitoring and quality control purposes. Well, you know full well it's not for that. It's to cover their backs. It's to cover themselves, and to make sure that if there was ever any dispute, they can go back and say, well, we told you this, we told you that. You can dress it up with the workforce quite easily and comfortably, and say that this is to make sure that if we have any complaints from customers, we can go back and see what was exactly what was said on an email or whatever it might be. But of course, you can equally use it for monitoring and making sure that your client's staff aren't going off and having inappropriate conversations with competitors. Other things you've got to think about, and I've listed just a few there on the slide. Again, I'm afraid you're not going to be able to see them very easily. But the data protection and privacy issues are obviously complex. Workplace privacy issues are very complex. I've just mentioned about CCTV, and it's not always entirely clear where the boundaries lie in relation to that sort of activity. And that would be probably a webinar in itself. But just be alive to the Data Protection Act. I put Data Protection Act 2018, of course, because that's a more recent one that's incorporated the GDPR. But there's also the Data Protection Act 1998, which many of the sections of that are also still in force. Regulation of Investigatory Powers Act 2000. Again, that's been overtaken by some subsequent primary legislation, but again, a lot of it is still in force. Telecommunications Lawful Business Practice Interception of Communications Regulations 2000, and the Human Rights Act, of course. Those are the sort of primary areas of legislation, statutes and statutory instruments that you need to keep in mind when you're advising your clients on this kind of approach. And of course, the other thing is you have to be very careful that anything your client does, it's not necessarily so much in monitoring, but if your client goes to an employee who they believe is going to go off and join a competitor, you've got to be careful that you're not encouraging your client to then induce a breach of contract that they might have if there's a forwarding contract to go and join that competitor when their notice comes to an end. So you need to be a little bit careful about and mindful of that. I'll come to that, I'll touch on it slightly when I come to team moves a little bit later on. So monitoring the employee behaviour, pretty obvious things here, a bit of common sense, but it never hurts to just remind ourselves of the sorts of things that we should be alive to and the client should be alive to. Is an employee coming to their client asking for a copy of the contract, particularly more than one employee? I mean, if you've had an inquiry within the same week from say 2 or 3 members of staff, I need a copy of my contract, I just want to check this point or that point. It's an unusual request, and it should alert a client to the possibility that there's something afoot in terms of what they might be up to. Changes in work patterns. Are they starting early, finishing late? Unusual requests for time off and absence. Changes to who the individuals are socialising with at work. These are all warning signs about the possibility that there might be a group of people thinking about leaving or moving. It might also be, even if it's just a couple of people, we talk about team moves, but a team move can be a team of 2. Communications, setting up group chats, group email or messaging platforms, using personal email accounts for what ostensibly seem to be work matters. unusual amount of time of calls between team members, communication between staff who don't usually communicate. All these things are warning signs that something might be about to happen. Just carrying that on a bit further, removal of confidential information. Again, I know this might be obvious, but emailing work documents to a private email address, that should be ringing alarm bells. Danger here is that, of course, with COVID and everyone working from home, they've got a perfect excuse to be doing that, which is why, again, some of the steps that I come on to a bit later are really pertinent now because of the push and the drive for everyone to be working from home. Remote access to work, where the employee doesn't usually work from home. Again, as I say, it's all come about now in a different way because, of course, remote access to work is going to be a really quite important in the circumstances. Resignations, when somebody resigns, what have they told you? What are the reason for the resignation? Does it sound true? Does it hang true? Again, these are the sorts of things that you need to be thinking about when if your client's coming to you and saying, well, I'm a bit worried about the possibility of this happening. Refusal to disclose the identity of a new employer. I mean, that's pretty suspicious, isn't it? If an individual isn't prepared to say where they're moving on to. And of course, the very, again, obvious one is the refusal, if you get to that stage, to give contractual undertakings post-resignation. I mean, by then, of course, it's looking very likely that something is up. If you've got to the stage where you are writing to your client's employee and saying, or ex-employee, and saying, just to remind you, these are the obligations you've got under the contract even after the termination of your employment, and then asking them to agree to that they confirm they accept those. If there's a silence or a refusal, and of course, furthermore, if you ask them to sign an undertaking and they refuse, that suggests, doesn't it, that they're up to something that they're not prepared to commit to agreeing to not breach their contracts. Proper recording and restriction of information. So these are the practical things that you can recommend to your clients that they do to ensure that they protect themselves from competition. The proper processing for recording client interaction and data. What systems does the client have in place to make sure that everything is down and contemporaneous, and there is a clear footprint or of what's happened in relation to each client. Daily activity log, again, similar thing. If you get particularly at the moment with COVID and everyone working from home, these are really important suggestions to your clients. Make sure that those people working from home are writing at the end of it or as they go throughout the day. I mean, solicitors are very used to this because, of course, solicitors have time recording. And it's one of the reasons why I switched to the bar. It's a bane of my life. Time recording and client billing and client care and all the rest of it, setting up files. And I switched. We don't have that at the bar. It's a wonderful luxury at the bar. But the fact is that you have time recording, very strict time recording as a solicitor. Well, your clients should equally be asking their employees to record a clear log of what they've been doing all day, who they've been having communications with, so that you can get an idea of what's been happening. Now, that's not unreasonable. Of course, it's all about the way it's done and how it's dressed up to the individual, but it's not an unreasonable thing to ask a client to do, and for a client to ask an employee to do. Use document management systems, restrict employees to using company equipment only. That's really important. I appreciate the budgetary constraints, but companies really should be only requiring employees to use their equipment, particularly mobile phones, actually, because immediately springs to mind laptops, but actually mobile phones are really important too, because if you can make sure that your employee has a separate mobile phone with a separate number, then you don't have this massive dispute when an employee leaves at the end, when this employee says, well, that number's been my number for the last 30 years. It's got all my lifetime, it's all my schoolmates know it, from years of old. I'm not going to give that up. If you give them a work phone from the outset, you can just take that away and those arguments fall away very easily. And have more than one employee working with each client. So monitoring communications and equipment, that's obviously a pretty common sense position when it comes to giving advice. But again, you need to think about this. Update any policy on email and electronic messaging platforms. Make sure that they are up to date. Bring them in line with what's going on and in society at the time. Because, as I say, I keep going on about it, but with the pandemic and everyone working from home, it's really important that these policies are up to date and what the employer can and can't do. It must permit monitoring, but you need to be aware of GDPR. The client needs to be aware of GDPR. And of course, if the client allows employees to use their work email for personal use, then that again raises GDPR issues and problems. That's why I say keep work and personal life very separate if you can. Leads me on the next bullet, limit personal use. Specify who owns the LinkedIn account, the Twitter account, the Facebook accounts. Again, people will come to you. It might be that you've taken over a business. When you're advising the client, it might be somebody's taken over a business. The employees that join the business, they will have LinkedIn accounts. What do you do about that? Well, again, your policy should be very clear on this. It should, at the very least, ensure that the employer, your client, can insist that any new business contact that's added to LinkedIn is also added to a database that the employer owns, so that when that individual leaves, they know that those are the individuals that have to be removed from their LinkedIn account. Very simple. That will hopefully take away the massive headache of how you extract from somebody's personal LinkedIn account your clients, your customers, those people who you don't want the ex-employee to compete with, to exploit, and if they join a competitor. It might be that your policy goes further than that the individual has to surrender their LinkedIn account. I would suggest that sort of thing ought to be an express contractual term rather than just a policy. But those are the things that you need to discuss with your clients depending on what their needs are. Telephone protocols, they're really important. Have a proxy access to email, so that when somebody's away or absent, ill, or even if they're not away, if they're busy for the day, they're going to a meeting with a client, that someone else can access their email and just monitor it, check what's going on. Obvious excuses for that, but of course that will promote access to information that you might not otherwise have. Monitoring the photocopier and use of printers. Again, most modern equipment of that kind keeps a note of what's been photocopied. This works the other way around too. If you're advising an ex-employee who's left, you need to check with them. Well, have you photocopied anything recently on the office equipment? All those sorts of things, because you don't want to find that your client is not being open with you and telling you exactly what they have been up to, only for you to write this strong rebuttal letter when you're faced with an allegation of competition. And then, of course, they send through the photocopier records to show that your client has gone and photocopied a confidential client list or something of that nature. So again, you should have access to that. Clients should use it. Those ex-employees you're advising should be aware that that's a possibility of what employers will use as a way of monitoring and policing competition. Work practices. Again, it might be common sense, I don't know, but there's lots of employers who resent staff going away for long periods of time, but actually they can't see the benefits of it. You should encourage your employer clients to allow their staff to take a fairly lengthy period of holiday, particularly those who they are a little bit worried about, because it gives a perfect opportunity to go and investigate and see just exactly what they've been up to. This is when the information starts to come through, little things get discovered. And as I've already mentioned, ensure that groups of employees deal with each customer. So you don't just have one employee dedicated to one customer, particularly if they're important customers or clients. Contractual protection, again, I mean, this is pretty obvious. As lawyers, we know what we've got to do in relation to contractual protection. And of course, it really sort of is a very brief outline, if you like, of what Colin's just been talking about for the first half of this webinar. But you need to make sure that they're enforceable post-termination restrictive covenants. Make sure that the contract has an express garden leave clause, because obviously that then eliminates the risk of an employee arguing that there's an implied duty to provide work. So you can't just leave them languishing in the garden. I have to say it's a dream of mine to be put on garden leave, but there we are. I'm self-employed. I won't ever have that. But but have that provision available so that if you want to stop somebody from competing, but you're worried about the extent to which your restricted covenants are enforceable, or more importantly, you don't want the cost and expense of having to litigate, then of course one of the most effective ways is to just be able to say to the employee, well, that's all lovely, you might well want to go and join so and so next week. You can't. I'm going to hold you to your notice period of 6 months. You go away, you sit and sit at home and do nothing for that period. That might well be a cheaper option for your employer client than actually the cost of litigating. And of course, don't forget there's also the risk of cross undertakings that the employer has to give if they want to seek an injunction to the court if it doesn't go their way at any final hearing. Disciplinary and suspension provisions, again, these should be up to date anyway. The idea that an employer wouldn't have these in existence is unheard of these days. But just make sure that there is provision to ensure that somebody can be suspended. Make sure that the policy refers to competing or abusing confidential information. Express fiduciary duties. Why leave it to chance as to whether or not somebody is a fiduciary? Why leave it to chance as to whether or not the implied duty of fidelity applies? Put in an express term specifying exactly what you expect. Of course, you need to be alive to the case law on this. You can't do anything that's extreme, but you can certainly, if you can justify why that's necessary, having a stricter and, if you like, an actual particularized express restriction or placing of fiduciary duties onto an express footing, then do so. If you've got a manager who's very good at their job, who's really critical to the business, you will want to make sure that fiduciary duties are there expressly set out in a contract. And of course, expand in the contract what is meant by confidential information. Make sure that the contract covers all the detail that the contract that the client regards as confidential. So turning to remedies, again, I'm going to be rather quick and skate over this quite quickly. We know what the remedies are. Garden leave, I mentioned, enforcing post-termination restrictive covenants, future harm, so you can get an injunction for springboard injunction. That's to make sure that where somebody's got a competitive advantage because they've acted unlawfully already, you can stop them from doing anything further. Breach of confidentiality, destruction, preservation and delivering up of documents, search orders. They're all powers of the court you might want to seek indulgence on. Damages, of course, let's not forget, we always talk about injunctions, but actually damages might be just as an effective remedy. In fact, injunctions might just be closing the door after the horse has bolted. And in fact, in some circumstances, you might find that getting, for example, a springboard injunction actually harms your client's case because it makes it much harder for them to prove the loss that they might otherwise have sustained. It's one of those catch-22 situations. But damages, you've got loss of profits from lost business, cost of retaining staff and establishing stability, cost of investigating wrongdoing, account of profits, negotiating damages. Now, I'll just touch on negotiating damages quickly. That might be an important remedy for some people. In fact, one of the questions I've seen already that's been asked is about what do you do? Well, if you can't actually show that there was any loss, they've gone to work for a competitor, but they're not actually using any of the confidential information that you're aware of, but you're worried that they might. Slightly difficult because the case that deals with this is a Morris Garner, that's hyphenated, Morris, M-O-R-R-I-S, Garner and another, and One Step Support Limited and another. It's a Supreme Court decision, 2018, UKSC 20, but that gives you a guide as to what negotiating damages are. But effectively what it is, it's the value of being able to negotiate with the ex-employee about relieving them from that restriction. But it's very much a proprietary thing. So you have to show that there was you're protecting some proprietary interest. And of course, in our case, in employment context, it's confidential information that you're protecting. So that might be valuable to you. Written and contractual undertakings, well, we know all about these. I'd be very surprised if anyone on this webinar doesn't know about them, but very often you will ask, before you even issue a claim, you'll get the ex-employee to sign undertakings. The value, of course, of those is if they don't give them, it infers they're going to breach. If they do give them, then it's very much harder for the ex-employee to say that the restrictive covenants were too wide in the first place. Undertakings to the court, again, that's taking it further. So what we were just talking about a moment ago was undertakings on a contractual basis. Now we're talking about undertakings to the court. Really serious stuff, because if you breach it, you're in contempt, you face imprisonment. Sort where the ex-employee can't be trusted with contractual undertakings, and they're given when an ex-employee or even a poacher, someone, a competitor, wants to avoid a contested application. I mean, those are obvious things, we know that. What's really important, of course, is with just before I move on to obtaining evidence, what's really important is making sure that any undertakings that are drafted are clear and concise and confined. Obviously, particularly undertakings to the court, if there's a risk of imprisonment, you want to know that whoever's signing that undertaking really understands what they're being asked to do. Obtaining evidence, sources and methods. Again, it's not rocket science, I suppose, to a certain extent, but the platforms that I've already discussed above, photocopier, technology, emails, all those things you will want to utilize for obtaining evidence. Require the employee to return their phone or laptop. Lock down the IT system before alerting the employee to the investigation. Have details of forensic IT experts to hand. Have your clients got that? They should have that, because these things happen literally within days or often minutes. They need to do something very, very quickly. Rigorous but responsible exit interviews. When somebody's leaving, really try and drill down and find out what's really going on, but obviously be careful not to breach the implied term of mutual trust and confidence. And of course, encourage others to spill the beans. I mentioned Tim sitting next to Sam, and he was going out with Sue. Go and talk to Tim, go and talk to Sue, go and see if you can find out a bit from them about what's going on and get them to do a statement. So considerations for ex-employers, ex-employees, that should be, there's a typo there. Sorry, no, it is ex-employers, I beg your pardon, I'm confusing myself. Considerations for ex-employers, options, what can you do? Well, you could try and persuade them to stay, of course, change of heart. If not, garden leave. I've already talked about that. Put them on garden leave. If not, suspend them. A short period of suspension while you investigate. That gives you the time to, while they're still employed, go through and find out exactly what they've been up to, just to see if they have been in breach of any duty of fidelity. And then, of course, you will go through a disciplinary process. That's really important, because sometimes the reaction of a client is, I just want them out. I don't want anything. I don't want them ever back. I don't ever see them again. Of course, that can't happen. If they've got more than 2 years service, your client's immediately inviting an unfair dismissal claim. So you've got to act within the constraints of what the Employment Rights Act says. So those are the things to think about. Report, this is one that is sometimes overlooked. Report an ex-employee, possibly to the Information Commissioner's office. It's a criminal offence for there to be a breach of the GDPR in certain circumstances. And if the ex-employees walked off with a whole load of personal data of individual clients and customers, that's a very powerful stick to beat an ex-employee with, to say, well, you carry on with that, you use that, and we'll have no hesitation in getting in touch with the ICO, and you'll be facing a prosecution, a criminal prosecution. And then, of course, there's springboard relief. And I've mentioned about the fact that that could hamper evidence later on of any loss. Managing confidential information when you're involved in litigation. I've set out the various rules, CPR rules on that slide. I'm not going to go into any great detail. Those are there for you to bear in mind if you're in this situation, things that you can do to manage confidential information and how to handle it. Because of course, you're going to need to produce confidential information to the court, but the difficulty here is, are you going to expose the client to more risk? Advising ex-employers and new employees, professional duties. Be alive to the torts of conspiracy and inducing breach of contract. This is now directly, I'm talking about you as solicitors now, and advisors. You could get caught up in this. The finger could actually start to be pointed at you and your obligations. Confirm what's lawful, what's not lawful in writing. Identify your client and limit the advice to those clients. That's really important, because if you've got, say, 2 or 3 people looking to move, and you've got a, often it's you might be approached by a company that wants to employ somebody, and they say, we want to employ these people, but we don't want to. Do not, under any circumstances, agree to meet the company client and the ex-employee who's joining them. That's a recipe for absolute disaster. Obvious conflicts there, professional conflicts. The soon-to-be employees, what's permitted and what isn't, what's permissible, what isn't. Well, you can seek to work with a competitor, you can acquire premises, purchase equipment, identify partners, you can even set up a company, contacting potential suppliers for details of products and prices within limits. These are all things you're allowed to do. What you're not allowed to do is prepare to compete during working hours, solicit customers, but that does require an element of persuasion. Or you can tell them that you're leaving, but if you tell them where you're going to and that you're going to a competitor, that's probably going straying over the border. Disrupting employer supply by soliciting supplies yourself, soliciting colleagues to leave, that's totally unacceptable. Assisting a competitor to recruit colleagues, you can't do that. Providing financial support to a new competitor, it might be that somebody's putting some money into a new business, thinking that they've got a place there in the future. Copying or memorizing confidential information, need it be said? I mean, that's pretty obvious, isn't it? New employers, the boundaries. Appoint a headhunter, independent recruiter, give them a written remit, so you can't be accused of inducing the tort of inducing a breach of contract. Use foreign employees to recruit others if they're outside of their post-termination restrictive covenants and they're not using any trade secrets or anything. Always obtain, there is a conflicted school of thought, but I think the best advice is always obtain contracts of potential employees to assess potential liability. Although it fixes the new employer with knowledge of the restrictive covenants, there's judicial skepticism of anyone who says they didn't know about this. And the reality is that your client needs to know what they're exposing themselves to in terms of risk. Limit the information that's shared between individuals as well. Make sure that if you're acting for the new employer, that they don't say too much, even to the new recruit. Responding to the threat of proceedings, these are the things you need to think about. Do you fight the injunction or do you give undertakings? Those are the questions you should be asking yourself when that you're confronted with that situation. How persuasive is the evidence for the defence? Is any new employer a true threat? Have individuals already given contractual undertakings? If so, then why should your client, the recruiter, give any undertakings at all? Because if the people that they're recruiting have already said they're not going to compete, that's fine. The ex-employer's got the protection. Will the court grant the relief? Is any undertaking sufficiently precise? And I would also suggest you resist split trials on liability and remedy, because those actually usually assist the claimant company in these cases rather than the defendant. And you might consider omitting breaches if actually the real argument is over causation and quantum. And that brings the talk that I'm giving in terms of practical tips to an end. You've got my contact details there. As I say, I apologise for the slides not being quite as clear as they should have been. If you want a set, you're very welcome to them, and they will be a clear set that you can read. So without further ado, I'll hand back to Colin.
Thank you very much, Stephen. I noticed that we're slightly over time. So what I think I proposed, well, what I'm going to suggest we do is that we end the webinar now. And so do feel as that you can leave if you wish. But if there are some of you who want to stay on, and I've got some questions, I've been busy on the Q&A box, then we'll stay online and we'll try and get through those questions. But so to formally end the webinar, I'll just say thank you very much to our marketing team, to Delphine, Hamish, Lisa. Of course, thanks also to Steve for being involved in matters. You will be sent the slides. I think you're also going to be sent a recording. If you're not, you can get it on YouTube anyway. Next webinar, 12th of November. You can influence the content of that, because I've seen emails that suggest they haven't decided what they want to talk about yet. There's been toing and froing about directors' duties, public interest disclosure, TUPE, but they haven't settled on a topic. So why don't you get in quick and email our marketing department and ask them to draft a bespoke webinar that will be broadcast on the 12th of November. Thank you very much for attending. We'll sign off now, but if you want to stay on and you want to ask us some more questions, then we will be available for that. So thank you very much.